This is Kristopher Leisten, and for this assignment I will be talking about the Racial Justice Act of 2009. The Racial Justice Act was enacted in response to McCluskey v. Kemp. McCluskey claimed that Georgia's capital sentencing process allowed racial discrimination. He used a study showing that African Americans convicted of the murder of whites were most likely to receive the death penalty. The Supreme Court rejected his claim and stated that, while bias may exist in sentencing, it should be the legislature, not the court, that should remedy the problems. The U.S. House of Representatives also responded to McCluskey v. Kemp by adding a federal Racial Justice Act to a crime bill in 1994. This act would allow defendants to use statistical evidence to show a pattern of racial discrimination in capital sentencing in their jurisdictions. Opponents of this act argued that it would abolish the death penalty. The act was dropped from the crime bill before it was passed. Also, in 1998, Kentucky was the first state to enact a Racial Justice Act. In 2009, North Carolina enacted their own Racial Justice Act because, over a 5-year period, 5 African American men on death row were proven innocent after spending a total of 60 years in prison. Under the North Carolina law, the defense could use statistical evidence of racial discrimination in capital sentencing. The state can respond with its own data, and a judge can make a ruling. If the judge found racial discrimination had occurred, the sentence could be reduced to life in prison without parole. Under the Racial Justice Act, defendants could present evidence in 3 categories. The first category was that death sentences were sought or imposed more frequently upon defendants of one race than others. The second was that death sentences were sought or imposed more often on behalf of victims of one race than others. And the third category was that race was a significant factor in decisions to exercise preemptory strikes in jury selection. The first ruling occurred from North Carolina Superior Court Judge Gregory Weeks in North Carolina v. Marcus Robinson on April 22, 2012. Robinson presented evidence in the preemptory strikes category. A set number of preemptory strikes are allowed to remove potential jurors that the prosecutors or defense believe would harm their case. The court found that prosecutors struck 52.6% of eligible black jurors compared to only 25.7% of all other eligible jurors. Judge Weeks stated, Robinson introduced a wealth of evidence showing the persistent, pervasive, and distorting role of race in jury selection throughout North Carolina. Robinson's death sentence was vacated, and he was resentenced to life in prison without parole. 150 other death row inmates also filed suit under the Racial Justice Act. Of those 150, 3 other inmates also had death sentences reduced to life in prison without parole. The Racial Justice Act was repealed in 2013. In December 2015, the North Carolina Supreme Court vacated the decisions in North Carolina v. Robinson and the 3 other cases. The court stated that the state did not have sufficient time to review and respond to the studies on racial bias in jury selection. The case was assigned to a new judge and is still pending. North Carolina Governor Pat McCrory agreed to repeal the Racial Justice Act because, quote, it effectively banned capital punishment in the state, end quote.